Good morning, everyone. Um, Yesterday evening, I was rather worried that the weather gods will play a havoc. But turns out it's the Saturday mood which has kept the audience a little at bay. But I'm hoping that once the event kickstarts and as we progress, more will trickle in. But I'm so glad to have all of you here present in person to spend a pleasant Saturday morning with us, both online and here in person. It shows that we are concerned, we are affected, and that we care about the status of infrastructure generally. And I think care we must, especially given what transpired yesterday. Uh, I think as citizens, we need to demand more. We need to demand for our dignity, and turns out we also need to demand for our survival. So it's only apt that today we are gathered here to talk about infrastructure, albeit in a different context, but public infrastructure which plays a critical role in democracy and enables access to justice. And I'm so glad and pleasantly surprised that all the dignitaries here have been way ahead of time. Justice Shakder was the first one to show up. Thank you so much for that. You have set the bar high. And a round of applause for that. As he said, the audit is mine to ensure that things start on time and everything runs smoothly. So here's hoping that that happens. I'm Deepika Kinhal. I'm a senior resident fellow at Vidhi Center for Legal Policy. I lead the judicial reforms vertical. We are the JALDI initiative, Justice, Access and Lowering Delays in India initiative, which is a multi-year mission seeking to study, understand, and solve for systemic issues that affect India's justice delivery systems. Today is a proud moment for us. I think this is the farthest that we have come in being actually able to provide solutions to a problem that we have struggled to understand and unravel over all these years. JALDI works on multiple themes. I won't take you through all of them. For that, we have a newly launched website, and I would urge you all to go through that. It's jaldi-vidhilegalpolicy.in. It's a shameless plug, but court infrastructure has been a theme that we have focused on for nearly 5-6 years now. We started in 2018 with a nationwide survey of 665 district courts across the country. And what we discovered through that survey were that basic amenities across district judiciary were currently not available. And by basic amenities, I mean drinking water, washrooms for women, signages, basic ramp facilities, and even where ramps are available, whether they are in fact usable. These were the various parameters that we looked at, and we looked at purely physical infrastructure. And the results were quite alarming, shocking, and disappointing. And since then, what we have struggled to do as lawyers, we are a team of lawyers here at Vidhi, and even JALDI comprises majorly of lawyers who have self-taught themselves to be data analysts, researchers, so on and so forth. But we understood that there are limitations to whether we can, in fact, solve for the issues that we are identifying on ground. And that was the genesis of JALDI Labs. JALDI Innovation Lab seeks to bring together experts from various domains who can actually solve for the problems that we identify through data analysis, through qualitative and quantitative research. What we are launching today before you is our very first interdisciplinary collaborative work, Court Design Handbook, a design guide to build user-centric district court complexes. It is with great pride that we are bringing this, and I'm not exaggerating, it is truly a labor of love. Multiple persons, multiple experts across various domains have contributed hours and hours of their time and expertise in bringing this book together. And it is my pleasure and privilege to be presenting this book before all of you, which will be launched by dignitaries within the judicial system for whom this is intended. And of course, the beneficiaries are going to be all of us. So I'm hoping that this will achieve the impact that it is intended for. I will take a brief minute to take us through the authors, the co-authors of this report. And I think the mention of their expertise itself will be telling of the diverse disciplines that have come together to put this report together. We of course have Ms. Shreya Tripathi and Priyamvada Shivaji, JALDI fellows, who are lawyers. We have Ms. Brinda Shastri, who is an architect and urban design expert, who is here with us today. She's traveled a very long distance, changing multiple flights to be here with us, given the number of flights that were cancelled yesterday. So thank you so much. We have Ms. Shreya Shetty and Bhagya Madhapur, who have joined us online. They are architect and accessibility experts. We have Mr. Abu Gayatri and Rama, who are designers. We have security and IT expert, Mr. Milind DP, who has also joined us online. We have acoustics expert, Mr. Arun Kumar, and I must tell you that collaborating and talking with each and every one of these experts has been so educative, so enlightening in terms of various aspects that need to come together to actually design and build a good, well-functioning court complex. I'm so grateful that the team has been working on this over the last 2 years, and they have visited multiple courts across the country, gathered information, spoken to multiple stakeholders. The consultations itself lasted several months. We released the draft way back in March, and then had multiple rounds of consultations and incorporated feedback into the final version that we are presenting before you all today. And with that, I do not want to go further into the details of the handbook itself. For that, we have a very small video. I hope you get deeper glimpse into what we have to offer with this video. Can we play the video, please?
District courts are the first avenues of justice for ordinary citizens in India. Litigants revere them as temples of justice, and for hundreds of lawyers, court staff, judges, and other service providers, they are places of work and livelihood. As India grows, our court systems must adapt to the needs of diverse users. Courts must become accessible, technology-enabled, and welcoming in the true sense. Since 2018, the JALDI team at Vidhi has been drawing attention to the status of judicial infrastructure in India. A survey undertaken of 665 district courts showed a lack of basic amenities to meet the needs of most users of the district courts. What would a modern, user-centric court complex look and feel like?
A couple of things that I would focus on. One is the entire navigation part of it. When I say navigation, I mean the ability to get in smoothly, get out smoothly, or the ability to navigate within the court complex from point A to point B. If you have to locate something, it should not be too difficult to locate, say a chamber or a particular courtroom. If you have to gather information from display board or from facilities like E-Seva Kendra, all of that process should be easy and smooth.
The elevators should be functional, and there should be more elevators. They should stop on all the floors, and so that pregnant lawyers can utilize those elevators to attend matters when they are spread across, say, 6 floors. They cannot run like others. For hygiene, the toilet facilities need to be better. Also, because pregnant women typically in their first trimester tend to have a fair bit of nausea, as I did, and you need to have a toilet that is readily accessible on every floor, that is also very clean.
Incorporating technology in sort of the various kind of administrative bureaucratic procedures that actually constitutes a large part of the work that we do, and that makes a big difference in our kind of experience in courts. Outside of just hearings that happen before the bench.
In the journey to make courts user-centric, it is necessary to understand the experiences of the day-to-day users of the court complexes. How is your experience with the court complex today?
So the first thing that I think of when I enter district court is how to figure out what numbers going on which court and when will my matter come up. The thing is, there is no display board which comprehensively will show you what's happening or what numbers going on in every court. So that would be a sort of infrastructural problem that I face. And even when you go to a court, go inside, sometimes it's not going serial number wise, there is no order, and that becomes a little difficult for litigants as well as counsels.
With the courts encouraging a lot of digital filing, e-filing and video conferencing hearings, it is very important that there is proper availability of internet in the courts.
मकानों की खस्ता हालत, मूलभूत सुविधाओं की कमी और दीवारों पर थूका हुआ, और there is no help desk to guide people.
A journey that could be bettered with the provision of sufficient physical and technological infrastructure. Infrastructure that includes e-hosting or web hosting of all papers filed in a case, quick and immediate updation of daily orders, interim orders or final orders, as well as a deeper and greater use of video conferencing facilities across the district court level.
As a practicing lawyer, I believe that provision for libraries, dedicated training rooms, conference rooms, canteens, it will help lawyers practicing in any court complex have a better day-to-day experience.
Another problem which a lot of people face when they enter the district court is with the lack of proper facilities for the people who are physically handicapped.
JALDI aims to work with the judiciary to transform courts into spaces where justice as an ideal is seen and experienced. JALDI presents its new report, Court Design Handbook, a design guide for a user-centric court complex in India. Our aim is to create modern and user-centric courts that meet the needs of the 21st century users. In collaboration with experts from interdisciplinary fields, the handbook aims to design courts that are accessible, adaptable, comfortable and safe, efficient and sustainable. What does your ideal court complex look like? Let's reimagine and build the courts of our future together.
I would like to thank Mr. Kinhal Agnihotri, who has edited and put this quite impactful video together. I think it will set the tone for how the audience can engage with the book that we have put together. And the key aspect is the sound bites that we gather directly from stakeholders on ground. I think that is what makes this book and I think our mission very enriching and consultative. Every step of the way, including here in the audience today, we have all categories of stakeholders. We have lawyers who suffer from visible and invisible disabilities, but they needn't have to suffer with it in court complexes, which are supposed to be quote-unquote temples of justice. With this, I would now like to bring to the podium Justice Shakder, who is our keynote speaker for the day. He, of course, needs no introduction, and I do not want to go through the introduction that is already available on the website in terms of his accomplishments as a lawyer, the contributions he has made as a judge, how he has been part of multiple administrative and judicial committees, and so on and so forth. But I think I will speak a little bit about the experience that I have had, sir, in working with you through your multiple initiatives over the last few years. I have had the pleasure and privilege of assisting you on your work, especially with the E-Committee, and now as part of the Accessibility Committee. And I think he truly embodies the Sanskrit verse, which loosely translates to "Let the wisdom come from all directions." He has been very supportive and encouraging of all of our work. Not just ours, multiple civil society organizations look up to him and have him as a ready sounding board for the initiatives that we want to work on. He has never discouraged or been skeptical about whatever work we take to him, and he's truly a champion of change within the judiciary, and we need more like you. I cannot think of a better person to launch this book, but please come to the podium for keynote address. Thank you so much.
think they don't know me.
We printed this. We printed this, so we wanted to use it.
Very good morning to all of you. Namaskar. And I must say, my dear friend from Chennai is here, so Vanakkam, Adab, Justice Rajiv, and greetings to everyone over here. In fact, Deepika saved me some blushes by not reading the CV, as is always done at most of these functions. He was appointed in so-and-so year, he became a senior advocate in so-and-so year, he represented, all that is gone. And for the 16 years that I have been on the bench, that's fading memory. What I now remember is what I have recently done as a judge. And there have been challenges, and both on the judicial side as well as on the administrative side. But there have been friends, seniors like Justice Badar, Chief Justice, both of them were Chief Justice, Justice Gita Mittal, former Chief Justices of the Jammu Kashmir High Court. In fact, they followed each other. But while they were in court, there was a lot to learn from them. And each one of them, I must say, and I've been saying this from every forum, have contributed so richly, and that's on the administrative side, judicial side, all of you would know, in their areas of interest that we've been able to take it forward. Like in IT, for example, the kind of work Justice Badadurai's Ahmed has done held us in good stead when COVID hit us. Justice Badar was preceded in this work by Justice Madan Lokur, and I don't know how many of you know that we started much earlier, which was in 2009. So when COVID hit us, Delhi was ahead of the game, as they call it. And I'm sure the experience of lawyers, both non-disabled and disabled, would have been much better in Delhi. I'm not saying it was perfect, because no one expected this, than in other courts. In fact, I got reports from lawyers who were in the Supreme Court, which is only a couple of kilometers away, telling us that they are able to navigate our systems much better than they were able to do it in the Supreme Court. But there is learning from each other. So the Supreme Court finally took to the same software that we were handling our work with during COVID. In fact, one of the things which Justice Badadurai's Ahmed would be interested in knowing, and it will make him happy, because in a sense these are the fathers, grandfathers of the system where IT is concerned. He won't like, that's not his age, but anyway, is that we did more VC hearings during COVID, and we are a very medium-sized court in the country. Then we have 11 judicial districts. Then larger courts, which have 3 times the number of judicial districts, and we were, yards away. I don't want to get into that comparison, because maybe they didn't have the facilities that we have, we had, and an early start. And therefore, my take is that when we are dealing with people who are differently abled, were we able to do enough? Well, there are some things that we have done. My friends here who belong to that, let's say, they are differently able to tell you that we have taken some steps, and some of the steps that we have taken, I would like to share with my colleagues over here. Like we have special parking lots for differently abled persons. We have changed the format of the cause list so that differently abled people are able to easily navigate it. And I must confess that one of the earliest signals that I got that there was something wrong was from Justice R.C. Chavan and Justice Gita Mittal. She in fact highlighted that and flagged it for me. This is the concern they have. They're, in a sense, not within the system, and yet they are involved with the system. And then of course we got other such inputs, and we were able to change the format of the cause list. So differently able people, I'm sure, are now able to handle it better. We have screen readers, for example, so that they're able to know, what is there in terms of content. Then we have impaneled recently sign language interpreters. How did we come by and do this? It's again an input that we got. In fact, we got a cue from a hearing that the Chief Justice of India had, where he appointed a sign language interpreter, and we realized that this is the need of the hour, and we immediately impaneled about, I think there are about 4 now. We gave them a good remuneration, and they are now on board. Anyone who wants can always, take recourse to their services. We have also gone ahead and done something which I was told is, very progressive, is to give e-inspection and e-records. Mr. Amar Jain, who's in the audience, said that I didn't feel so empowered when I got to know that this is something that the Delhi High Court is doing. So that you can be sitting anywhere and you could get the record, on your machine, and then you could sort of argue your cases before the judge is concerned. Let's say, in a more collaborative manner, you would be able to assist the court better. Because one of the things that I do find which is something about changing mindsets. I would be the first one to confess that it's a process where you sensitize yourself vis-a-vis needs of the others. I now realize that when you're hearing a differently abled person, you need to speak slowly. You need to be patient. You need to speak coherently. You can't hustle them and say, and that's what happens, because in the Indian system we have a cause list where others are waiting, and your colleagues need to be more patient, because invariably what used to happen is when I was a lawyer, we were sitting and some fellow ahead of me was taking longer than necessary. You'd say, outside we go, and this fellow doesn't end his arguments, how will my matter reach? Now when a colleague of yours, is differently abled, you need to imbibe in you or imbue yourself with a certain amount of sensitivity that this man is trying his best, and therefore give him that space. Now, unless we change our mindsets, it's not going to be easy for them. Now, when I look around and I looked at this, I had the occasion of having a preview of this wonderful court design book that Deepika and her JALDI team has come up with, is that in Delhi we have lifts which don't have an audio-visual arrangement. So someone who's visually impaired doesn't know which floor he is on unless there is an audio input. Or someone who's deaf, he needs a visual input. So those are the things that are missing. Now, we don't have as yet, and we are working on it, tactile tiles. We don't have signages. We need signages which are also in Braille so that people can know where they are going. As in the video you noticed just now, someone said we need an access route. So someone who enters a building who's differently able should have a map either on the website if he's able to navigate that, or otherwise, where he needs to know as to how the lay of the court is, so that if he needs to go to place A, he should be able to go by the shortest route to place A and not end up in place B or C and then be taken around. So these are the kind of things that are missing. I'm aware of that, but we've started that. We started that because now, fortunately, we've merged 3 segments of something which is interlinked, which is IT, AI for whatever it is at this stage, and accessibility, because these are things which actually at some stage merge together, and if you have one committee handling it, it's easier to progress certain things. One other thing that I am very, very enthused about is online dispute resolution. If we get that going in our country, in our judicial system, it will help immensely, especially people who are differently abled, senior citizens, who are not able to come to court. It's not because we'll reduce the footfall. It's because they can sit in the comfort of their home and they can do their work or, if necessary, interact with the court. But what we have today is rules, and they've been for quite some time, they've been updated, of remote hearings, for example. We've done it for non-disabled people, where evidence is recorded and especially in IPR matters, where evidence is recorded of a person sitting in US. He doesn't have to come miles down. But imagine the difference it would make for people who are differently abled if we are able to push ODR the way it should be. Now, these are those small steps. If taken, it will improve the life of litigants, especially represented litigants, lawyers who are differently abled. We have, for example, 34 paperless courts for Negotiable Instruments Act. There are certain handicaps. We are trying to learn from that. But for check bouncing cases, it's there. If it is for check bouncing cases, why can't it be there for other cases? Is a question that the Delhi High Court is thinking about. But I can share that with you. Even the E-Committee in the Supreme Court is thinking about. So integration of the judicial process with ICT is, in my view, the way forward. If you do that, we'd be in a very comfortable zone. But as I said, there are problems. I mean, I just mentioned a number of glitches that you can easily note. In fact, I was just speaking to my friend, Justice Swaminathan. He's a parent of a differently abled child. His wife, Kamakshi, and they are in Madurai, is working with differently abled children. So I was just speaking to her on the phone, and she said, Rajiv, there are certain things which you can know only via lived experience. So I said, Kamakshi, what comes from the top of your head? She said, for example, you have lifts. So I said, what's the problem with the lifts? She said, well, the problem with the lifts is they don't remain open long enough for a wheelchair person to get in. Now, this is something that would never come to our mind till you have actually taken a person in sitting on a lift inside that lift. Then she said, you have washrooms, for example. So the conventional wisdom is that the washroom, because of water not getting out of the washroom, you have it at a lower level than the main floor level. She said, but this doesn't work for differently abled persons, because every time he goes in, there's a problem. And especially they have a spine injury or something, it will affect them. You come into the court, invariably you find that the court entrance has this sort of a mesh or whatever you may call it at the main entrance for the water to get into the main drain. It doesn't work for them. You put them on a wheelchair, it will hurt their, especially if it's a spinal injury. Now, fire extinguishers, she said, you have it at a particular level, or a biometric apparatus, you have it at a particular level. A person who's, he's not, he's dwarfism, he's suffering from dwarfism. He can't get to that level, correct? And therefore, access to court, physical access to court is inhibited. A visually impaired person doesn't see it. When he's moving on in the passage, his shoulder often hits the fire extinguisher. Now, these are things that you will never be able to correct, and these are small adjustments that you have to make if you will not speak to people who've gone through this experience. So my endeavor always has been, and Deepika has worked with me on other projects also. We've done a policy document which is concerning privacy and data protection. And I've always told Deepika and other members of the team, there were several of them, that please don't give me a report which will be kept on a shelf, which will be dusted after 10 years, 15 years, and nothing is going to. Give me a report which is implemented. You must have a immediate target and a medium and a long-term target. So fortunately, when Deepika and I were working on that other document, privacy and data management, we spoke about this, and she said, Justice Shakder, we have the necessary wherewithal to do an accessibility audit. But as Justice Badar and Justice Gita would know, that there is bureaucracy in our court also. So she gave me a proposal. I said, give me a proposal. She gave me a proposal in January. And typically, and this is something which is known to all lawyers, that you are able to push certain things on the administrative side as you rise the food ladder, correct? So as so I came to a situation where I had to tell some of the senior judges that, listen, we need to do this. There was a problem about budgeting. They said you need to negotiate. Fortunately, one member of my team in the accessibility team was also in the BMC team, because what happens is it's like a cabinet ministries, it goes from one committee to another committee, and then if you're not on that committee, and then it sort of rolls back, and then it goes to the chief or the acting chief, as we have in Delhi. So finally I told these fellows, I said, listen, they want some PWD, otherwise they'll spend lakhs on renovating other buildings. Agree to something, make them happy. They did, and they got this mandate to audit. So JALDI is going to do, I hope, very quickly, JALDI, the audit for high courts, and hopefully, if I'm still there, we can expand it to the district courts. But as I said, I've told Deepika that we need to take into account the views of users, the view of maybe parents who bring their ward to courts. And nothing will change unless you have access. Nothing will change unless you speak to them. I'll give you 2 examples, and you know why I'm saying speaking makes a lot of difference. So we have a accessibility WhatsApp group. I'm part of it. I read it, and I don't intervene till I'm called upon to deal. So sometimes I was joking with, I don't know whether I told Rahul this, Rahul is part of this group, that I feel like the president of the Residents Welfare Association. So someone will write saying, आज pass नहीं मिला, sir, आज हमको case file नहीं मिली. So then I gently tell, my registrar or one officer who's been dedicated to look after this that, please look into it. So it's done quietly, but it helps because they know I am part of the group, and there is that necessary alacrity in doing, because Judge Sahab wahan hai, not because it only matters till you're there, as most of us have realized. So it helps. And the accessibility group then organized a meeting about a couple of months back to speak to various stakeholders, lawyers who are suffering these problems. And after the meeting was over, one of these chaps, I didn't know, he came from Telangana, and he came up to me and he spoke, and he said, sir, the problems that people put before you and the suggestions and the solutions that we got were commendable, but there is one issue that I am facing which I don't know, no one seems to have an answer. So I said, he's from Telangana, he was a scheduled caste, and so I said, what's the problem? He said, sir, I don't have a toilet in my house. And that's when I thought, we can give him all the other things, but if he doesn't have, he says, sir, I feel humiliated every day of my life. So, fortunately, by this time, as I said, as you rise, I've now become the head of the Delhi Legal Services Committee. So I told my secretary, please speak to the Legal Services Authority person there. I'm sure there are schemes. And this talking helped to progress something which was not remotely connected with Delhi. So it doesn't matter where you are, what you are doing, it is important that you speak to people. Then we had another engagement. So we had this, this young man is here, I didn't know. And he's, as you can see, he came up to me after the meeting and he said, sir, I don't have work. So you can give them access to physical infrastructure, you can give them functional access to websites, but you don't provide them work. Now, even for someone who's in the profession, to prove to himself he does not have it within him. I went through it, I'm sure others, when they were lawyers, they went through it, and we are non-disabled persons. We needed work to prove to ourselves that we are good enough to do what others can do, who I call the entitled lot in our profession. So I called up other members of the committee and I said, Delhi Legal Services Committee, you know how it is. So the secretary and all, we have a youngish chap now who I've got here, very talented. I said, listen, Arul, we need to do something about this. He said, what? The panel is already made. The panel will change in December. I said, no. If we come to December, I will be gone, you will be gone, and nothing will happen. So, and in any case, it takes 6 months. Why can't we start the process now? You call for applications, there will be interviews. And I am very happy. What we have done is, we've called for applications. There are about 7 panels, criminal 1, criminal 2, civil, etc., labor. In every one of them, we have 1 slot reserved for differently abled people. Now, he will tell you, now at that time, now there's a pro bono panel. We put him there. He advises people. And he gets that satisfaction. He told me, money is not my concern, sir. What I need is work. So I urge all of you who are in a position to help these people. If you farm out work, I wish more of them were here. If you farm out work, whether it is a former judge or a lawyer, if you give it to a junior, why can't you give it to someone like them? And I can tell you, they are as good as, if not better, than a non-disabled lawyer. We had a case concerning a transfer, a differently abled person. He was being transferred from Delhi to Chhattisgarh. He had a lawyer who was non-disabled. I decided to appoint Rahul as an amicus, because it's very difficult to understand, even from a lawyer engaged by a non-disabled, as to what he's going through. We had him, and I can tell you, the argument was only on law and facts. There was no attempt by any one of them to, seek sympathy or pull at our heartstrings, as they say. But Rahul's presence in the court sent a message to a lot of people. A, you need to give them work. See them in action. They are as good as anyone else. And he could send a message to his colleagues or his brethren that we can be as good or better than them. So ladies and gentlemen, I end with this. I know Bhadrath told me long ago, more than 20 minutes people lose interest. So I keep all these advices somewhere at the back of my mind. So before you go to sleep, I can only say that the work is not over, it is just about started. You feel like that Greek character, Sisyphus, who tries to take a boulder up the hill and it keeps rolling down, and you keep carrying it up and it keeps rolling down. But someday we'll have the boulder right at the top and we'll succeed. Thank you very much for the patience. Thank you. God bless you.
Thank you so much, sir, for that. And specifically the Sisyphus analogy as well. I was thinking about it when you said it, but then you said it, so now I don't have to say it to wrap up what you just said. But I think personally that was very helpful for us as well. We spent 2 long years working on just identifying what these non-negotiable standards should be, what an ideal code should look like. But as you said, the real journey begins now with implementing these. And that's what we hope to do, carrying this conversation forward after today as well with all of you. By the way, I'm Priyambada Shivaji. I also work with the JALDI initiative, and I'm one of the co-authors on this report. And before we continue, I just want to say we also have a team of fantastic volunteers here today. So if anyone requires any additional assistance or support, please feel free to reach out to us at any point during the event. Now, before we officially launch the print version of the handbook, we also want to take this chance to tell you that we are providing this handbook in an easily accessible and navigable format on our newly launched website, the website that Deepika mentioned. I just want to show you, this is in keeping with our ongoing efforts to ensure accessibility for all. We know this is a very bulky document, 540 pages. You should have seen the draft, that was 1,000 pages. But the goal is to ensure that this is available in an easily accessible format for everyone. This is our newly launched website, where you can also, at a later point of time, check out all our other past and present work that we've done on different issues surrounding judiciary as well. but specifically with regard to the Court Design Handbook. I just want to show you what it looks like so that you can explore this at your own time. You can scroll through the navigable tab here, this blue tab, where all the components of the handbook have been mentioned in detail. And the handbook covers, just to be clear, the handbook covers both the kind of the principles that we use as our basis for why for the whatever we say. Sorry, let me just rephrase that. When we say courts should be ideal, what do we mean by ideal courts? We spend the introductory parts of the handbook talking about those principles and why we've established that these are the principles we need to look into. And we've looked at each space of the court, of a district court in particular, in detail. And this includes from design standards, what it should look like. We've provided images, representative images, and figures and floor plans and layouts, which we hope would be useful in building such ideal court complexes. And on our website, if you click on image descriptions, there's a tab here for each image or figure. So we've provided text descriptions for all of these images and figures here as well for ensuring that this can be accessible to everyone. So please feel free to explore this at your own time. Our hope with the work that we've done is, again, as you said, so not to leave it on a shelf somewhere. We want to ensure that this is actually taken up. So please feel free to use our website. You can also download the PDF from the website if you prefer, or read it directly on the website. But also, we are here today to launch the print version of our handbook. So if I could invite all our honorable judges onto the stage to officially officially launch the handbook, please.
No, he's ditching us.
No,
oh, come
Disability audit done 8 years ago.
Yeah, I know. No.
It's there.
Wonderful witnesses.
No, a disability audit of the courts.
Good.
Anyway,
point is going, report.
when do we officially raise it?
Deepika, you've not got the ribbon and the... so we are not used to it.
Thank you for your support and endorsement. Thank you.
There are interpretive rules also in existence since 2010.
Okay, good.
So we can continue with the panel discussion.
Okay.
Yes. Just to keep things going, we will now begin with the first panel discussion for the day. And our panelists here, as you can see, are eminent judges. Thank you so much, sir. Thank you. We have Justice Naveen Rao, Justice Vidhi Ahmed, Justice Gita Mittal, and we also have Rahul Bajaj. Where's Rahul? And I'll hand it over to Deepika, who will be moderating this panel.
ऑन ही रहेगा तो हम आपस में भी बात कर सकते हैं ठीक है
I'll take the liberty to begin despite the power outage. I think this provides a nice setting nonetheless.
None of us can see now.
We are equalized. Right, I think I'll take a cue from my introduction with Justice Shakder, which he appreciated. So I will not go into the list of dates and events for all the dignitaries on the panel. Okay, the light is back. What I'll instead do is, of course, identify how each one of you have played a key role in putting this book together at various points in time, and how in your own way you have made a difference to the cause that we are all here for, which is reimagining and building courts of our future in an accessible and user-centric way. We have with us Justice Badar. Justice Badar has been a judge of Delhi High Court and retired as Chief Justice of Jammu and Kashmir High Court. He headed the committee, the National Court Management Systems Committee on Infrastructure. Him along with Justice Muralidhar put together an extremely comprehensive baseline report on court infrastructure way back in 2012. And that has served as a basis for all of our work on court infrastructure since 2018. Of course, I will pose quite a few questions to Justice Badar on what he thinks about what has happened since the report has come out. But he has been one of the first persons that we consulted when we started out with this project, and he was extremely encouraging, and that is what has got us this far. We have Justice Gita Mittal. Justice Mittal has been a source of huge support and encouragement for our work through and through. She of course also, as Justice Shakder mentioned, has retired as Chief Justice of Jammu and Kashmir High Court. During her stints at Delhi High Court and Jammu and Kashmir High Court, she took various initiatives on the administrative side, and particularly with respect to court infrastructure, digital and physical. We will, of course, hear from her directly on some of those initiatives. But more recently, she has been the chairperson of the Vulnerable Witness Deposition Center Committee that the Supreme Court constituted. And as a chairperson of that committee, she has put together, again, a very comprehensive set of guidelines that is serving to put up VWDC centers across all district courts in the country. And we will hear more about the effectiveness and the implementation of those guidelines during the course of our discussion. We have Justice Naveen Rao, who has traveled all the way from Hyderabad to be here with us. Thank you so much, sir, for your effort and your support. I crossed paths with Justice Naveen Rao when I was visiting the High Court of Telangana to present another report. And it so happened that that was when he had just inaugurated an integrated family court complex in Hyderabad, which is one of its kind. And he has also led the construction of an extremely accessible and user-centric district court complex in Warangal district in Telangana. In the handbook itself, you will see a lot of pictures that we have taken from that district court complex, and you will see the commendable work that he has led from the front. He's here with us today to share his experience on what it took to make that happen, what it took to change the mindset and bring in the right kind of expertise to create a model district court the way he did. We then have Mr. Rahul Bajaj. Rahul wears several hats, one of which is also that of being a senior associate fellow at Vidhi Center for Legal Policy. He works extensively with the disability team at Vidhi. He is also part of the accessibility committee at the Delhi High Court, and I'm eager to hear from him about the experiences that he has had as member of the accessibility committee and what it takes really to put forth the needs and requirements of a large section of the stakeholder community, which has so far been ignored at various levels. Of course, it is not to say that no change or no improvements have happened, and that is what we will hear from all the judges today. But why is it that those changes continue to remain exceptions? I think those are the perspectives that we will get from Rahul, who is a practicing lawyer at Delhi High Court and Supreme Court, and he is also a co-founder of Mission Accessibility, which looks at increasing accessibility across various fora. With that brief introduction, let me kickstart the session for today. And I'll start with you, Justice Badr. As I mentioned, it's the NCMS committee report, which truly set the benchmark on what district courts should truly look like, what they should feel like, what should be the various facilities. And the report itself that you had put together goes into details of specific measurements, what are the various facilities, gives an extensive list. And when we looked at the report, it felt like, yes, this is it. If the district courts and the high courts follow this, then soon we will have accessible, inclusive, user-centric court infrastructure. But in 2018, when we commissioned a survey across 665 district courts, as I mentioned, the results were definitely not what we expected. What I want to understand from you, sir, based on your extensive experience within the system, and now that you've also been out and you observe what is happening, where is the gap between the talk and the walk, right? How can we bridge this? What are the administrative hurdles or capacity constraints that judges have to work within, which has resulted in this gap, which continues to persist?
Can I use sitting here itself? Can you hear me? Can everybody hear me? See, when we started I was in the NCMS committee, which was instituted by Justice Kapadia and then carried forward by future Chief Justices. And there were judges from different regions of this country, east, west, north, south, and I happened to be selected from the north. And each of us, while deliberating on various aspects of court management systems, was given a particular brief. The brief given to me was with regard to infrastructure and, of course, a little bit of how to attain that infrastructure, that is budgeting. Now, when we set upon this task, I brought into the fold Justice Muralidhar also, and an architect who had designed our district court at Saket, which I think is still a model court. There is another very exceptional district court in the country, which all of you should see, and I think Justice Mittal will agree with me, is the Srinagar District Court. And these two courts are really exceptional as a modern district court. And then we also involved a member from the government, who was the Joint Secretary, Mr. Gulati, to bring in the government perspective as to how the government would see this project. Now, when we started at that point of time, it was a clean slate, right? So we started with what is exactly the requirement of a courtroom, what is the size and dimension, how do we build a district court, which may have different sizes. For example, a district court in Sikkim will not be the same as a district court in Delhi. I mean, you have 80 courts in Saket, but you will have maybe just one court or two courtrooms in Sikkim in a district court. And of course, in outlying areas in Leh and Ladakh, which Justice Mittal will point out, I had gone to a district court at Hundar, and I asked the civil judge there, how many cases do you have? He says, we have 3 cases. So I said, what do you do the rest of the time? He says, we don't decide these cases because otherwise we'll have none left. So what he does is he says, I go with my aides and assistants into the village and ask them, किसी का झगड़ा हुआ है, कहीं कुछ हुआ है, तो बताओ. But there seem to be all peace prevailing in that area, so they don't have any cases. So that is one size of a district court or a civil court. And then there is the size of district courts in large cities like Bombay, Delhi, and Calcutta, and Chennai. So there are differences. And therefore, we said that we must have a modular approach to it. You have a single court, and then you also have a court which has 6 courts, maybe 8 courts, and 40 courts. And all this should be modular in the sense that if you want to expand from 4 to 8, all you need to do is add another floor. So your foundation should be strong enough to later on add another floor and have 8 courts. So that was the general idea behind the court infrastructure. Then, of course, at that time, a lot of work was going on information technology and e-courts and infrastructure. In fact, I had started the first e-court in Delhi in 2009, and Justice Bhatt never forgives me because he keeps saying that you used me as a guinea pig, because he was the first e-court in the original site in Delhi. But since then, lots of things have happened. Lots of things have happened. And what you are saying is exactly right, that what we hoped would happen did not happen. One of the reasons was that we had hoped that the NCMS would similarly be translated into states as the SCMSs, that is the state management, court management committees. And what we had recommended was that the tenure of the members should be such that there should be some who are senior judges, there are some who are middling judges, and there are some who are new, because somebody has to carry it forward. Project has to be owned. Unless the project is owned by a committee or a high court, it will not happen. Unfortunately, in some states it worked, in some states it did not work. And I can give you an example. For example, in West Bengal, Justice Deepika Mittal, who is now in the Supreme Court, he was also later on a member of our NCMS on a different aspect. But he said, I just took your report and implemented it in district courts in West Bengal, wherever new courts were coming up. But there is one thing which I see in your report, which is interesting, is retrofitting existing courts, which is also actually required, because you don't want to waste the resource that you already have, but you want to build on it. And so that's a good development. The actual crunch comes where the question of money comes. If you don't have money, you cannot build any court or build any infrastructure. And that money has to come from the government. So one has to be, your Chief Justice has to be persuasive, your committees have to be persuasive as to how to convince the government that, look, it is in the interest of everybody that the court infrastructure is improved. So this is one of the lacunae that I found, is that budgetary resources were not there, as a result of which infrastructure could not develop at the rate at which it should have developed. Secondly, in the meanwhile, lots of things have happened. The entire court structure needs a complete new look to it. Why? Because of technology. And now, of course, AI. If you want me to talk more about it, I'll talk to you.
I'll come back to you for that specifically, sir.
Yeah.
But there were quite a few points that you highlighted, which I want to take to other speakers to get their inputs on that. One of which is the need for judges across various seniority levels to be part of the committee, so that there is continuity in the issues that are taken up, in the initiatives that are taken up for reform, and also the budgeting constraint that you identified. I'm trying to draw a distinction between initiatives that are taken up by the judiciary internally, like what happened with NCMS, which is almost entirely judges driven, but on the administrative side, and the initiative taken on the judicial side, ma'am. And this is where I come to you, Justice Mittal, because currently you are leading an initiative which is driven by an underlying order and judgment of the Supreme Court. Do you see whether there is any difference in the way the implementation happens when an initiative is backed by a judicial order, or is it again up against the same set of hurdles that Justice Badr spoke about, especially in the infrastructure front?
First, an inclusive greeting to all our friends who are here. Namaskar, Sat Sri Akal, Assalamu Alaikum Salam, Vanakkam, Jule from Ladakh, Very inclusive greeting. Greetings. That's the ethos of our country. It doesn't matter what part of the world you are, what time of the day it is, they remain relevant. Unlike a good morning to somebody who's in the United States of America, joined on a VC would be completely irrelevant and ridiculous at this point of the day. So inclusion is the ethos of our society. And thank you, Deepika, for joining me on this panel. And that I see some of my favorite people in the room are here. Rahul, I knew would be there, but I see Nipun is also here. Nipun Malhotra wasn't here? I thought I saw him. Oh, I see. Okay. But my sensitivity, we are actually, I see that we are contextualizing inclusion in relation to disability. But I just want to point, I'll take 2 minutes if I may, to point out 2 very distinct examples, both of which came to me on the judicial side of exclusion by court methods and court reasons. One was a person, I was sitting on the division bench hearing a revision against an order of maintenance against a poor man. And the man said he didn't have the money. He had been ordered to pay about 20,000 rupees per month to his wife and 3 children by the magistrate in a proceeding under section 125 of the CRPC. His appeal to the district judge failed and he had brought a revision to the High Court. So first thing, when you see a matrimonial matter and you see 3 women and a young little boy, 2 daughters, a son and a woman on the other side, and a man and looking for maintenance, you try to see if you can resolve this issue. So I passed an order for personal appearance of the man so that we could explore whether they could go in for mediation. This man, as the address showed on the memo of parties, came from a very poor village in Uttar Pradesh. On the day fixed for the hearing, kept calling the case again. I didn't like to proceed ex parte again and again and again. Kept it over after lunch, and the lawyer was extremely frustrated, the man's lawyer, that he's come to Delhi, he's come to court, I don't know why he's not in the courtroom. What transpired, finally that man said that he's not being given an entry pass by the court registry because he did not have an Aadhaar card. He had no documents of identification. And that was the reason why he was not permitted access. So I called the registrar into the court and I said, why are you asking for an Aadhaar card? You take a photograph, you take biometrics. Where is it the requirement under the Constitution or under any criminal procedure code or CPC that you must produce a document of identification? There are so many people in this country who do not have sources of identification. And they said, no, after there was a bomb blast outside the High Court, the court committee put together these rules, and helter-skelter, it's a mandatory requirement to have a document of identification. You still have that rule to enter the Delhi High Court. So I had written a huge judgment that this is, anti-access to the court, access and hence access to the justice, and there shouldn't be any requirement, and requested that the matter be placed before the Chief Justice to take a relook into it. Unfortunately, my bench partner disagreed. It went to a 3rd judge who didn't agree with me and agreed with my bench partner, and it never has been examined. But till date, now you can see how poverty, this man was too poor. He was a laborer who daily wager from some remote part of Uttar Pradesh who did not have means of access. So financial inability, financial penury can be a huge barrier to access to courts in a premier high court like Delhi. Then second, Justice Shakder mentioned about how you need to be a caregiver of a disabled person to understand, I'm just pointing out some instances what you can do as a judge and as in the judiciary. There was this case by a brigadier in the army who said he had been transferred to a remote part of the country. He was posted from Dehradun. He wanted to be there for a few more months because his son, who was suffering from cerebral palsy and several other diseases and was completely immobilized, he had to be lifted into the wheelchair, etc. He was the only caregiver for him, and he said he was doing some special course at an Asha school run for specially able people by the army. So generals came to oppose this writ petitions, arguing how many times will we grant this person favorable postings of his choice. So I put it to that person. I asked the brigadier and the general who were in court. I said, are you trying to say that this man actually asked for a disabled child so that he could take a posting of his choice with you? So there was utter silence. There was silence on the other side. I asked them to run an audit as to cut a long story short. Asked them, these people, to give me an audit. They said it will disrupt army discipline. We can't keep accommodating. Transfer is an exigency of service. They're correct in law. But I said, give me an audit of how many people you have who are caretakers for disabled people. They didn't even have 400 such personnel. They had never done this audit. So judicially you could pass orders directing the army, the Indian army, to frame special policies for people who were caretakers for disabled dependents, and I expanded the dependents to include divorced daughters and parents and parents-in-laws also, to make accommodation. And ultimately a few more writ petitions came up, and we were able to get proper rules for caretakers for disabled people, not only in the Indian Army but for all the paramilitary forces, which includes the CRPF, ITPP, all these forces. We were able to do them by judicial orders. It took a lot of monitoring, but we succeeded. So therefore it is very, very important to understand that you need to be sensitive to if you have a matter before you, you need to look at the right involved. So in this brigadier's case, what the court had argued, what our opinion had been, that the case does not involve rights of the brigadier. No, he is not, but it involves the Article 21 right to life of the disabled child. A 18-year-old child cannot be lifted by the mother. It's very difficult to find caregivers for disabled people, especially if they're suffering from mental disabilities and mental difficulties. It's very, very difficult. You're almost jailed. I filed a writ petition as a lawyer, when I was a lawyer, on behalf of the autistic. And I remember interviewing hosts of parents who had autistic children, some of them with even two children, one autistic, one mentally challenged with other problems, and the kind of problems they face. They said the nukkad banana seller, the fruit seller, will give you a banana for 2 rupees. With me, he'll charge 25 rupees. I said, why is that? He said, because he knows I've got 2 children in my car who will be so impatient, they won't let me stop the car for even 2 minutes. So, this is the kind of sensitivity which society has. And, we are not even patient. I had passed a rule when I was an acting Chief Justice. We had a special window for the elderly and people with special needs to be able to do their filing out of turn. Otherwise you stand at a window with a bunch of sheaf of papers. So I had appointed a transgender on contract basis. She's still there, to run the wheelchair service in the High Court, where you could book a wheelchair in advance, like you do at the airport. There's a lot of people do that. So, we were able to look at 2 sensitivities simultaneously. The transgender needed to be empowered, and people needed to know that she could serve, and wheelchair need was addressed. So far as coming to the question which Deepika has asked, this, I had a case, how this judicial proceedings came to be and how I got into this committee. A case involving an allegation of rape by a 7-year-old Tamilian girl living in Delhi. And she had been, who had accused a 19-year-old neighbor of having raped her. Now the allegations which the legal aid lawyer who's arguing the appeal after the conviction, 7 years after the incident, was that there was no evidence. So I said, a 7-year-old child's statement, why are you so anxiously insisting I hear it? You think I'll be able to overturn a conviction? He said, there's no evidence. So I said, let's begin. The statements on which this young boy had been convicted included, there was a 161 statement, that's the statement recorded by the police officer saying, galat kaam. That boy had done galat kaam. The 164 statement, which is a statement on oath recorded during investigation, said buri harkate. Nothing more than that. And the statement recorded by the trial court judge, a sessions judge, said something equally innocuous and ridiculous. So the ingredients of section 375, the offense of rape at that time, were not made out. The trial court, so I had to ultimately acquit the the boy, but by then he had spent 7 years in jail. And the allegation that boy's defense was that the girl's father had borrowed money from him, and when he asked for return, that's why he was implicated. So, and it was a very sad case. The child's background showed that she was a daughter of a Tamilian driver whose mother had, abandoned these two when she was a baby. So she wouldn't have had any clue about sexual relations. And her statement obviously appeared to be tutored. But more difficulty one difficulty which this case threw up was linguistics can be a barrier. We don't know what the child said. She was a Tamilian child. So when I wrote the judgment, I had collated a whole bunch of guidelines laid down by the Supreme Court in recording testimony of rape victim, how FIR is to be recorded, how the trial should be done, how medical examination should be done. Sakshi, Gurmeet Kaur, all of you would be knowing all these judgments. So I collated these guidelines were all over the place in judgments from the 80s till 2007 or 8 when I had written in one place. But linguistics was a barrier. And also we imagine the plight of a child or a woman or a person who is disabled, who can't speak, is speech impaired, is hearing impaired, is mentally challenged, is visually, impaired, and then how do you get the identification to be recorded? Judges don't get trainings in these methods, I put this question repeatedly to trial court judges. Would you believe in identification by a mentally challenged person? Identifying somebody as a guilty person. Most places, almost 100%, the answer is, I've been doing trainings across the country now, and across the country I've dealt with thousands and thousands of judges. The answer is they won't believe, So then you ask them that mentally challenged person is able to identify somebody who, as their mother, as their father, as their sister or their brother. Why is that? It's because they are able to relate to the love and, attention and care that is showered on them. So why will you disbelieve that child or that adult mentally challenged person when he or she identifies somebody as the inflictor of the worst kind of pain on them? So, these are issues, Can a visually impaired person be a witness to a will? Where you have to witness the execution. These are questions which have never been raised and I don't even know if there are instances of this, but these are questions with which I have been testing judges and to which I find no answers. So I collate out all these guidelines, and after I pronounced that judgment of acquittal, the Justice A.P. Shah had appointed a committee in the High Court. I was there and Justice Reva Khetrapal, and to see, he had called me and told me in his chamber that he would like to see that these guidelines are implemented in Delhi. Now this committee, talking of, now Badar has mentioned, Justice Ahmed has mentioned budget. I want to tell you, again, this has been my refrain across the country, that even without budget, you can ensure inclusion and justice. And it is up to the judge. So what we looked at was what can be done. What are the handicaps now? There's something called secondary traumatization, which a witness of a dangerous crime, especially sexual violence, faces when they're called to recount in the court. And this has to be overcome. So how can we do it? Now, to begin with, if I was to begin with how the FIR is to be recorded, I'm bringing bottoms up, which is not the way. I feel if you begin top down, it flows in faster. It has, once, and everybody is engaging with the court system. The witness is there, the victim is there, the police is there, lawyers are there. So if you begin with a system, you sensitize your system, it goes down automatically. So we had begun top down. So I did an international examination. I engaged with organizations in Canada called Families in Court in London, Ontario, child witnesses in South Africa, looked at rules from Zaire, USSR, South America, South Africa, New Zealand. Whenever I got the chance and I was abroad, I would visit a court and look at special facilities. And, what I found was, in my discussions with victims of sexual violence and dangerous crimes, is that, CRPC provides a procedure. The maximum sensitization, now Juvenile Justice Act has a few better provisions, is that you do a camera trial. But when I spoke to, victims of sexual violence, if you've heard of Suzette Jordan, she was a victim of a gang rape known as the Park Street gang rape in Kolkata, and trainings which I did as part of that committee, she was one of the resource persons, and she would tell us that, when you do a camera trial, you think you're doing justice. You remove even my mother, my sister, my friend who's come to court to assist me, they will not tutor me if I'm holding their hand. But to me, it's so much reassurance in a room where gang rape meant 5 accused people. 5 accused people means 5 lawyers, 5 juniors, 5 munchies, bundles of files, a prosecutor. She says, I had nobody in the court. The prosecutor was not my family friend. These are exact words. So, that's the only protection that the law has given victims of dangerous crime. Or that's the only protection which a camera trial gives. It shields you from the press, random lawyers, etc. But you isolate the witness and so it's not enough. So when I looked at examples, the only place that I found some sensitive courtrooms was in the Scandinavian countries. And there's some of this is there in New Zealand and Australia. But Asia, nothing. Europe, nothing. America, I haven't seen anything, like that. Even England didn't have this. They were using screens like we do in our courtrooms. You put a screen between the witness and the rest of the room. But the witness has been waiting on the same bench as the accused outside the courtroom 4 hours, 5 hours, 3 hours, 2 hours till the case is called out, Probably has come in the same public bus. So we devised a system by which we have been able to prevent, and in this I'm talking of 2010, complete interface between the system, court system, and the victim or the witness of a dangerous crime. But this, just designing a courtroom wasn't enough. So we had a Tamilian witness. Now we had three barriers here. One is the secondary traumatization. Will come to you. Language as a barrier. Tamilian witness in India, Constitution recognizes 28 languages. So you could have a witness of any language in your courtroom. So you needed interpreters. So in Delhi we framed interpreters rules in 2010. We had prescribed a fee which included sign language. Unfortunately, those rules are also, Justice Shakder didn't know about them. They're lying somewhere in the files in the High Court. But we had made the rules, and sign language interpreters, assistants for, visually impaired, even mental health experts to assist the court in recording the testimony of mental health experts. So this was the first thing that we did. Second thing, while undertaking the physical design of the courtroom, we undertook an exercise of describing a protocol as to how the courtroom has to be worked. Again, this was with a national and international confabulation. Vidhi wasn't there when I was doing this, but I've used Deepika and her team and others from Vidhi all the time. I randomly call them whenever I have a legal issue or any kind of assistance or guidance. But we use people from Madras. Justice Prabhasri Devan was part of our helping us. We had Vidya, if you know Tulir, if any of you have heard of it, she works with children in Madras. We had Professor Ved Kumari, we had Gita Ramaseshan, we had Roma sitting here. She was part of the trainings that we did on in disability, Voices from the Margins included. And then we defined the protocol, and we did designed a training module while designing the physical courtroom. Now, physical courtroom, how do I do it? I have no budget, and Delhi there's no land. So you can't build new complexes, you can't build new structures. So I had to craft this from an existing courtroom. When I called the district judges and told them that I need to design need to put in place a vulnerable witness courtroom, so they all laughed except one district court, Karkarduma, Justice Teji. He later came to the High Court. Justice Teji was a district judge there, and he gave me one court. Now I had my everything was ready. All I needed was a courtroom, and I needed the judge's chamber, and I needed an adjoining Elmat's room. So, and a corridor from which I crafted a waiting area. I had no budget. So from this existing courtroom that he gave, we crafted a vulnerable witness deposition complex. The judge's chamber was converted into a witness room. We hived off a place out of the corridor into a waiting area, pantry and a toilet for the witness. And we used the judge's entrance as a special entrance to bring in these witnesses. We still do it. Now, there's not enough time, but we were able to implement and inaugurate the first courtroom on 16th of September 2012. But again, one thing where we will fail is in commencing a program without doing an audit. India specializes in designing, executing and implementing all projects, all construction activity without ever taking a physical audit of the number of cases, number of footfall, people having a footfall, etc. And so when I did an audit of the number of cases, we had defined in the protocol who would be a vulnerable witness. So people who were covered under the definition of vulnerable witness was so much that that courtroom would have been completely ineffective and inefficient. So we restricted, the definition said a child witness would per se be vulnerable, and we included, and so we restricted it to only children, so I had to redefine my protocol. But the first courtroom in Delhi was inaugurated on 16th of September 2012. And thereafter, till 2018, when I left Delhi, we had designed these, we had implemented this in every courtroom. And part of the program, we included that we would use legal aid lawyers, we use them, and to bring the witness from the residence. Initially, they were very upset. You know, you're sending a official card to our residents, the old neighbors, and everybody comes to know that we are going to court. But when they saw that the respect and the treatment that they were receiving at the hands of the judges and the court staff, and they were segregated, we had the pantry gave them food. You know, if the case was spilled over, there were snacks, etc. They were so happy that if the case got adjourned, they wanted to bring uncles, aunts, thais, and everybody to the courtroom with them when they came for the next visit. And you know, part of the design also included involving experts. I had psychologists, Dr. Achal Bhagat, visit the courtroom. You know, I had spoken to Justice U.U. Lalati, who was still a senior advocate, taking his advice on several steps in the courtroom. And this work was very successful. The witnesses, the judges said the testimony has been transformed. You know, Professor Satish Minal is undertaking a study as to what has been the impact on the outcome of the cases, how many convictions. We don't have that as yet, but that study is still ongoing. It's not over. And under orders of the Supreme Court, you know, this was needed. Secondary traumatization, there's no interface between the victim. Victim is in the witness room and the accused is in the courtroom. In case the witness, studies from America showed that some of the witnesses, or no, not America, Scandinavian countries, said that witnesses were upset. They wanted to tell the judge. They feel that the judge is the ultimate medication for all the pain. So they wanted to tell the judge. So if the witness wanted to be in the courtroom, we've had to isolate the accused. So that we've hived off space with a one-way looking glass, a very simple model, like the room at the back. That one-way looking glass would end that glass would be one-way looking, and the accused can see into the courtroom, but you can't see into that room. So the accused is brought in after the judge is in the room in the court, so the judge knows that the accused is there. So this is ongoing. We have had to redefine the protocol into 2024. Every high court, all 28 high courts, or the high courts in the country, have implemented the protocol suggested. We've also given a plan as to what facilities must be provided, and it's takes into consideration all the special needs which are covered. And what I have found in my travels is, when I visited a vulnerable witness complex in Dharmapuri in Tamil Nadu, what I was told was, when I saw the courtroom, it was this room is not where the whole trial takes place. This is a room where a judge goes to record the testimony of a vulnerable witness. The room was double the size of this room, these 2 seminar halls. You know, so you could actually craft out. I actually told them how to redefine it into 6 vulnerable witnesses, 1 facility. Other high courts are reporting that land acquisition is underway. Somebody else is put out a budget of crores of rupees. So my trainings have included architects, engineers, chief engineers and chief architects of all the states, wherever I've gone. And I've made films on what can be done, film on what has been done in Delhi and what is needed to make a room without special budget, special funding, with very minor tweaks in the existing structure, using simple things. You can use 2 laptops, and today with the Bluetooth, etc., be able to record the testimony, just separating the witness, giving the witness a special treatment. So this is so that you don't waste money. Land acquisition today is a very expensive proposition. Places like Delhi, there's no land to acquire. So how you can tweak existing facilities, it's purely a judicial initiative and judicial intervention. What has helped the Supreme Court order has helped that it's being taken across the country. And other day I was doing an inauguration of such courts. I was asked by the Chief Justice of the Calcutta High Court, and in 24 paraganas, to have a conversation even by trial court magistrates and judges of having consultants, psychologists, no paintings on the wall because children are prone to suggestion, was so empowering. It's so nice to see such things happening. Northeast, it's begun. So, it's very heartening. So, it's judicial initiative, judicial intervention, and you can do with minimal budget,
That I think is the key.
Minimal budget, and no budget actually. The IT section of the High Court, the Supreme Court has given so much money. But just two very small points I'd like to, I don't know whether you already planned it, but there's one thing which I'm very sensitive to, which I saw in the United Kingdom, lockups, Lockups are where prisoners are brought from the jail, and where it's a holding area for a prisoner in the courtroom, And in England, I saw that, legal aid lawyers actually get a chance to meet their clients, meet the assigned litigant in the lockup before they go to court. In India, we didn't have this practice. So in Delhi, I was able to introduce this. Second is lack of witness rooms. What you get a random summon from some court. You're a layman. You've never been to the court. You've seen something and you get a witness. You don't know what to do. Room number 32, Tisazari, where there's 300 courts. Who do you go to? What are you supposed to do? What if you can't do? You're a surgeon who's been called for an emergency surgery. What do you do? So, you need to provide witness rooms where a witness should report. And it should be the responsibility of the person in that room. So this should be part of the design. The third thing I'd like to suggest is childcare rooms, a pregnant staff member, a pregnant litigant, or somebody who comes back after having delivered a baby. They need special rooms to be able to be comfortable, and so these we haven't thought of. I introduced them in the Srinagar District Court, which Badar talked about. So we have a witness waiting room.
As in the whole list, ma'am, it's just extremely inspiring, and I hope we are able to, extract just this talk of yours to identify what are the various initiatives that the judge can take within his or her capacity, despite all the constraints that exist on the administrative side, the financial side, all of that. So I think it's
one more thing. Sorry. If I know, since I won't get this opportunity and you're going to do it on an all India level, since we have all the architects who've helped you put this together, I hope you put in ramps taking up to the court. No, going up to the dais in the court.
Yes.
And for the courts, for the court staff.
Court staff.
I have seen somebody who had mobility difficulties, a steno, who had to come in from the front, and there were steps, so that can be very mind-boggling.
Yeah, I think the philosophy that has that underlies most of the recommendations in the handbook is that all of us are potentially disabled, right? So that is the idea which has guided each and every recommendation. So it is not just for a section of the population or a section of the population that is currently using the premises. It is to ensure that every category of user, irrespective of what may happen to them tomorrow, day after, they are able to come and access justice and be a provider of justice in various capacities, be it judge, court staff. So ma'am, I think even if not all, some of the examples that you spoke about have been featured in the design handbook. What I would pick from what you mentioned, and it is heartening to see the progress that has been made with the VWDC initiative, and it is informative, I think, for the likes of us who work on judicial reforms and who have consistently questioned this particular point, and I know I'm going to rake up controversy by mentioning this on this panel, is that the intermingling of administrative and judicial functions may not be the best way to enable reforms within the judiciary. But from what we have heard from the panelists so far, it takes a certain bent of mind to even understand the problems before proceeding to solve for it. And I think that is why judicial officers and judges at the High Court and Supreme Court level have helmed all the initiatives and reforms so far. But going forward, should that continue to be the case is something that we need to ask ourselves, and that is something that the judiciary needs to introspect from within. Do they have enough capacity? And that is something I would like to bring to all the panelists here if time permits, or maybe one of you can ask in the question and answer session. But I will quickly now go to Justice Naveen Rao, who I mentioned has undertaken this commendable effort of creating an accessible user-centric district court complex in Telangana. I have twofold questions for you, sir. One, what did it take to actually break away from the routine of building one district court after the other, which look exactly similar, and actually bring in the kind of expertise which led you to reimagine and build a very different kind of court complex? And second, what do you see are the challenges in continuing with this effort? How do we ensure that this doesn't become a one-off instance? We don't need to have model courts, one in every state. How can we ensure that every district court becomes an all-inclusive user-centric court?
Namaskaram to all of you. Fortunately for me, I became the member of building committee, it's called, in Telangana, at the early stage of my career. So, as a junior member, I was spending a lot of time in discussing with the other brother judges regarding various aspects.
On the Zoom, somebody has unmuted. Mute all. You can choose mute all.
So when I became in charge of Warangal district, the first thing I noticed was that there were no facilities available in the family court. An existing administrative building was converted into a family court. There was no space for the family members to sit, wait for the cases to be called. So I thought the family court is something different from regular courts. It requires special facilities to be provided. So I've taken up the task of converting an adjacent building for providing the basic amenities in a family court. Like first is a waiting hall, a play area for the children who come with their parents who are fighting the litigation, and a creche facility for these parents to keep the children the creche, and so that they can pay attention to their case. One other important aspect I've noticed which is required and was not provided anywhere was a baby feeding room and a diaper change room, including a machine which provides diapers. So these facilities were provided. And to my surprise, when certain interviews were conducted with the litigants who come to the courts, they were uniformly saying that after these facilities are provided, they were able to come to court with free, open mind and attend to the cases. Earlier they were not coming because there was no facility to take care of the children, young children. So they were having a lot of trouble, and the children were troubling them when they were sitting in the courtrooms, etc. So these facilities improved. And when I was interacting with the judicial officers also, there is a change of mindset of the people coming to the family courts also. So this was encouraging to me. At that time, a building of 10 court complex was planned in the year 2009. It was sanctioned in 2009. Foundation was laid in 2012 because there was some objection raised by the lawyers that they don't want the existing library building to be removed. So it took 3 years for convincing the lawyers, and then they changed the building plan itself to accommodate the existing building, not to remove that building. And by 2020, only civil structure was over building. And to my surprise and shock, there were no electrical designs planned even before the construction took place. By then it was not even there. No outlets were created for sanitary, the outflow, the water, etc. This was shocking to me. And then in the meantime, as in the several meetings that were taking place, I was proposing certain changes to be made, but they were not happening. Like my senior members, the bench, the committee were not acceptable, or things were not moving properly. Then when I became in charge of the Warangal district, I thought this is the best opportunity for me to do something for the creation of judicial infrastructure, so it can be a model to other districts to emulate. So I then looked at the building plans of 2009 and saw several deficiencies in required parameters for a building. And then your report of 2008 came in handy, which report also covered Warangal and has laid down the parameters of what are the deficiencies noticed in Warangal complex. That took as a base for me to look at the building designs. And then since it was in the initial stages of the building, I had the opportunity of changing the internal arrangements to suit to the requirements of the modern day. And then I worked it out. Ultimately, it came out so well, and I exceeded the parameters prescribed by you. I added something, other things required which may not have been noticed at that point of time. What I've noticed in the process was that the stakeholders are not taken care of in planning the buildings, particularly the judicial buildings. No proper provision was made for the litigants to sit. This Warangal court complex is a very big complex, but there was no seating arrangement made for the litigants to sit. Even the 10-court complex did not envisage any seating arrangement. There was no place for the litigants to have their lunch. Minimum the requirement is that they will have lunch, no washrooms as usual in every court complex, and no facilities for the staff of the court. There were no change rooms for them, no place where they can have their lunch. As you know, that the staff take out their lunch on the table which they work during the lunch hour, and then that's the unfortunate thing. No facilities as usual for the lawyers also. Lawyers are the great sacrificers. Whenever a new court is sanctioned, they say that, sir, you can use our association room for converting the court, because they're more interested in having another court. Then it is converted and they are not provided any place for them to sit or anything. So when all these things were thought about when I designed the court complex, and it has come out well. Even disabled friendly was not there. The modern technology facilities, because in 2009, use of technology was not even envisaged in the judiciary. So all the facilities are provided, online facilities, like now Honorable Justice Chandrachud has introduced the court video conferencing facilities. So all the courtrooms are provided with video conferencing facilities. They can access everything. Notice boards were put up. Direction marks were put up everywhere, how to go. The battery cars are provided for the disabled people and the senior citizens. When it comes to the development of a family court in Hyderabad, again, I've experience of converting family court in Warangal. I noticed that in most of the family courts, the basic facilities are not provided. One other thing is, along with the litigants, the spouses who are fighting the dispute, their children come, and then generally their parents also come to court. No facilities are provided to take care of the elderly people, particularly in the family courts, though in other courts also if elderly people do come. But I thought in the family courts, the more flow of elderly people along with their spouses, the children, and the younger children also to be taken care of by these elderly people, grandparents. I specially made rooms for the seating arrangement for the elderly people. Special chairs were provided to them. Lunch facilities are provided to them. Creche in this building, particularly in Karimnagar, Hyderabad, creche facility, play area. And I persuaded Hare Rama Hare Krishna Foundation to establish a restaurant on the top floor of the building. They will supply the good food at a reasonable cost. So all these facilities are provided. Again, the inquiries revealed that there is a change of attitude in the litigants also. There were more flow into the litigation courtrooms. They are attending in time and they are attending to the cases. One other thing, as Justice Gita has highlighted, about the POXO courts particularly. In Warangal, as you must have seen, most of the time when the Supreme Court gave directions to establish POXO courts, Government of India laid down certain norms and immediately fixed some time schedule. Existing courts were simply converted into POXO court, like simply converted, change of board only. They were the same courts, but they are now called as the POXO court cases, cases dealing with POXO, court dealing with POXO cases. No other facilities are provided, whereas there are specific requirements of the special courts. So when I I concentrated again in Warangal Court Complex to establish a separate POXO court. The existing furniture in the court complex, old furniture, were converted into the waiting chairs in the courtroom, and they look like the school. The court hall is converted into like a classroom with the color benches put up. All the different colors were put up in their benches, and height of the judge podium is also of this size. And judge was requested not to wear the regular court dress. Right. Separate waiting hall for the children with all the playing area, playing facilities were provided to them. The air-conditioned court, the waiting hall is provided. Separate access to the children who come to to give evidence along with their parents. The separate gate is provided, and they will come only from that gate. Right. And they were given access to this the family court facility is provided, so that the children can go and spend time in the Chirek also, in the child facilities place and play area also. Again, there is the change of mindset, and I was told by the presiding officer after a few months that their conviction rate has increased because the witnesses were able to speak freely because they were not able to encounter the same problem they were facing earlier. So this experience showed that if you provide right facilities, infrastructure facilities, it also will automatically provide for increasing the disposal rate, expediting the disposal rate.
That is a very critical finding, and I think that goes on to show that infrastructure has such a key role to play in the entire justice experience itself, both for seeker and provider of justice. Like, unfortunately, even today, whenever a person enters a district court complex, the feeling that is imposed on them is that of helplessness, there is confusion, there is intimidation.
One other thing I would like to add is the main problems, 4 problems are planning, execution, finance, and post-construction maintenance. That's the biggest problem. The judicial officers are not paying attention to maintenance of the buildings. They just come and go. They think that their duty is only to go sit in the court and pass orders or decide the cases. They don't concentrate on the maintenance aspect of the building and welfare of the stakeholders in the building. The principal district judges, they don't concentrate. The funding problem, in so far as Telangana is concerned, whatever the budget sought by the High Court was provided.
Right.
They sanction the buildings. The problem is releasing of the money. They don't release the money when the contractor executes the work. So no good contractor is willing to come and execute the work relating to the judiciary.
Right. This actually is a continuing concern across all the measures that judiciary seems to be undertaking. The lack of complete control over being able to fund these initiatives and the coordination issues that exist between the judiciary and the executive wing. I think this is a key area that we need to tackle, and that is something that the judiciary needs to address, I think, on a war footing, because ultimately what I understand, which we totally appreciate, that all the judges are going out of their way in taking these initiatives, making these reforms happen, but at the end of the day, it is an additional responsibility that the judges are taking. How do we ensure that the capacity constraint that is there internally, ultimately it may be the judge signing off on these decisions, but are they equipped, even at the district judiciary level, with the principal district judge who is dealing with lakhs of cases on a monthly, yearly basis? How do we equip them and support them with the right kind of expertise and staff, so that whatever initiative is taken, they have the capacity to continue with it? I think these two aspects, the funding, coordination, and the expertise and capacity problem, needs to be addressed. But sir, I would like to...
1 minute, I'll clarify this. In Warangal, with the maintenance aspect, I call the lawyers and the staff, the association of the staff. They said, this is your building. This is like your home. And in fact, we spend more time in the court than at our home. I'm here today, I may not be here tomorrow, but you will be here forever. So maintenance has to be taken care of by you more than anybody else. Yeah. And in fact, it really worked. And I was told later that the staff was paying particular attention to see that the facilities are maintained properly.
Yeah, I think you've hit the nail on its head. So lawyers and court staff, they are the permanent stakeholders in any court complex. And if they can be made to feel like a part of the initiative, I think the change management and adoption will be much quicker. And I must apologize for bringing in Rahul this late, but I think it is only apt, Rahul, that you have the last word on this topic. As a key stakeholder, as someone who has been part of the accessibility committee and has seen accessibility initiatives across board, I want your take on what the judiciary has been able to provide so far, and where do you think the gap exists between what we aspire for and what we are currently getting? I know your primary practice is still in Delhi, and I want you to also shed light on whether that was a conscious decision, given that Delhi seems to have some of the better facilities, and whether that is in fact a constraint on your ability to practice elsewhere. But overall, your take on the status of infrastructure, what we currently aspire for as 21st century Indian citizens, and where we are. Over to you. I'll just get the mic closer to you.
Right. Okay, so thanks very much, Deepika, for this opportunity. You've asked 3 questions really. One is on the current state of the infrastructure. So given that we're talking about district courts, I can share 1 or 2 quick examples from my experience of practicing in the courts. I've appeared in various district courts, Saket, Patiala House, Rohini, Tisazari, etc. Now, one part is being able to, I mean, I'm not restating, at the risk of repetition, I think it is important to mention the point about being able to locate the courtroom in a timely manner as a blind person is extremely difficult, in the sense that, at any rate in district courts, things are not as well structured as they are in the High Court. Very often the online cause lists and those that are placed outside the courtroom do not match. There's always that issue, but if you aren't going with the same cited person to that court on 2 occasions, it will be very difficult for the person to help you, locate the courtroom. So if it's X who's going with you on 1 occasion and a different person later on, then for them to be, because it's very difficult for you to remember in such a big court complex where everything is. So I think having a textual map of the court premises, and I know that there are security concerns with this, which Justice Bhatt had flagged to me when I had suggested this in the context of the Supreme Court. So there may be security concerns, but there should be a way to have a textual map of like, okay, when you get in 500 feet, you have to walk in front, then, if you turn to the left, X comes, if you turn to the right, Y comes, so that you can try to internalize that and plan for it, because you don't have something like Google Maps, which is giving you left and right directions here. So that's a big issue. And the second one is that in my experience of having navigated the district courts, it's always been with cited support. It's kind of impossible, I would think, to be able to do it on your own with as someone who has a visual impairment. So therefore, I'm not aware of any tactile pavements that exist in the district courts. I've never used them. But auditory cues is something which I think should be worked on, in the sense that there should be a way for me to be able to make out like what the courtroom number is. If we can install some kind of an audio system where you can just press a button outside the courtroom and it can tell you what court number it is, that kind of thing I guess would definitely be helpful. In terms of the work already being done in the accessibility committee, Justice Shakder already has covered most of them. One point though which is quite important, which he did not cover, I'll just flag it, is there was a 2016 circular by the then Chief Justice of the Delhi High Court about prioritization of cases involving litigants with disabilities. And we found that this circular was because I had made a query about this, that as to if some measures are being taken to prioritize their cases, and it was then that it came up in one of the meetings of the accessibility committee that there was such a circular from 2016, but practically it was not being implemented. So the accessibility committee then led by Justice Shakder evolved a practical mechanism for this to be done, in the sense that now when you see the cause lists, and if there is a case involving a person with a disability, that can be indicated in the, that is indicated in the cause list itself, and then such matters are prioritized in terms of appearing higher up in the advanced list. The other issue here was also that the court system didn't have a way of knowing what cases involve persons with disabilities. So they actually said that, there is no case at all which has a disabled litigant. But I pointed out that I am myself arguing 4 or 5 such cases. And so now there is a way for you to indicate it when you file it going forward. In terms of sort of the way ahead, 3 things I will just quickly flag for the district courts. I think one is accessibility audits are extremely important. So the High Court has commissioned an audit now which Vidhi is conducting. But I think the district courts should also do those, and Justice Shakder flagged this in the morning, because they also have accessibility committees which can commission such audits. Right. The second thing is ensuring that a person, a litigant or lawyer, is able to, and this is not there at the district court level now, in the High Court it's there, that they are able to confidentially indicate their disability at the time of filing a matter. And confidentiality is also important here, because one may not want to be recognized in an order as, okay, this is a disabled lawyer, because you don't want to be pigeonholed into that category. But right. At the same time, if there are accommodations you need, the system has to have a way of being able to know that you are a person with a disability, because it's not always realistic in open court to say that, oh look, if I'm having some difficulty locating like some document which is in hard copy form, that may be because of my visual impairment. Every time one may not want to undergo that process. So if the judge already knows, that would help, not in terms of giving any undue advantage, but just in terms of leveling the playing field. Right. And the third point and the final one is mainstreaming accessibility. So I'll just give you one quick example of how the Delhi High Court has done this recently. So they came out with the e-true copy rules for, individuals to be able to obtain true copy versions of their paper books. And the rules basically say that if it is available in digital form, then you have to provide that. But if it is not available, you can be turned away. Like, they don't have to scan and digitize it. But in the case of persons with disabilities, it expressly says that you can't kind of turn them away on this basis. You have to take that extra effort of doing the scanning and making it digitally available. So just being very proactive about accessibility in mainstream judicial and administrative interventions may be helpful.
Thank you, Rahul. Am I audible?
Yes.
Thank you so much, Rahul. I think those are extremely helpful, and I think overall the panel discussion today is filled with rich insights, examples as to what has been done and what more needs to be done. I hope all the stakeholders in the judiciary, especially at the district judiciary level, are listening to this and will take home lessons on what can be done even within the constraints that the judiciary operates under. Thank you so much, all the panelists, for sparing your valuable time and for candidly talking about what has gone into making some of the reform measures that that we have seen in the judiciary. I hope it becomes the norm, so that we are no longer talking about one-off example of a model court here and there. I would also like to end with double-clicking on one point that Justice Mittal mentioned, which is that audits need to guide the changes that are brought about in the judiciary. And to facilitate that, the Court Design Handbook webpage hosts a self-audit checklist. The intention behind this is that we don't have to wait for once every 5 years surveys and audits that are commissioned nationwide like we had to do. It is a very resource intensive exercise, and it is not possible for us to keep updating data from across the country. So what we have tried to do here is empower each and every one of you who's a court user to use that readily available checklist and conduct an audit yourself. And we would be more than happy to host the results of that audit and take it forward with the stakeholders within the judiciary. I hope this is something that the audience here and the online audience will check out later. For now, sir and ma'am, thank you so much for coming in and sharing your experiences with us. I hope this has been an engaging and insightful conversation for all of you. Thank you so much. Thank you, Rahul.
Thank you. Thank you.